The last video discussed the case Jacques versus Steenberg Homes, which offers a very strong conception of property law's right to exclude, the ability of a property owner to keep others out, and the willingness of the law to vindicate that right without inquiring into the owner's reasons for excluding others. This video discusses a contrasting vision offered by the case State versus Schack, which treats the right to exclude as much more contingent and dependent on the circumstances. The defendants worked for government-funded organizations that provide healthcare and legal services to migrant farm workers, and the case arose when they entered into farmland against the wishes of the owner of the property. The owner of the land refused to let the lawyer defendants see his client, a migrant worker, without the owner of the land being present, and he generally refused to let the defendants visit the workers at their living quarters on the property. And so the defendants were convicted of trespass, and the New Jersey Supreme Court overturned the convictions. The court takes a very different tack on the nature of property rights, saying, ownership of real property does not include the right to bar access to governmental services. The court invokes this principle that property rights cannot be used to cause harm, and that's a principle that's normally associated with the law of nuisance. But here the farmer isn't doing anything in particular to affect someone else in their use and enjoyment of their property, and the court acknowledges this is hardly a precise solvent of actual controversies, but in this case, the maxim, this idea of not doing harm with your property rights, the maxim does express the inevitable proposition that rights are relative, and there must be an accommodation when they meet. And so this idea that there has to be a balancing of interests between the parties involved, the court saying necessity may justify entry upon the lands of another because property rights serve human values, that we're not just thinking about property rights as being useful in and of themselves, but rather different interests that are human-centered. Title to land does not amount to dominion over the destiny over those on the property. And the court says that the well-being of the farm workers must remain the paramount concern of a system of law. State versus Schack, of course, is a particular case arising on a particular set of facts, but it's worth taking a step back and considering how exactly do we reconcile this case with Jacques versus Steenberg Homes, the case we talked about in the last video. Why aren't the farm owners' property rights vindicated when the Jacques were? What exactly is the distinction here? So we might say this idea the court leans on about there being harm done to the people on the property. But you could actually make a case that in Jacques versus Steenberg Homes, the Jacques were imposing a harm on Steenberg Homes by refusing to allow them to cross over their property. And that led to difficulty on the part of the company and presumably their clients. And so what really is the difference between the two situations beyond perhaps a implicit judgment that the interests of the affected parties in State versus Schack are more important than the ones that are at stake in Jacques versus Steenberg Homes? And of course, fair enough, but it underscores this idea that property rights are not really absolute at all, but under the right circumstances, a court will engage in balancing that interest against other kinds of interests. And here the court says, we're not saying that everybody needs to be allowed in. We're not saying that the farm owner can't impose some kinds of limitations, but the employer may not deny the worker his privacy or interfere with his opportunity to live with dignity and to enjoy associations customary among our citizens. These rights are too fundamental to be denied on the basis of an interest in real property and too fragile to be left to the unequal bargaining strength of the parties. And so how should we understand how Schack arrives at these conclusions? Not so much that it arrives at these conclusions, but what does it mean from the perspective of the legal system? For example, is this a case about reallocating wealth and power between the farm owner and his workers? Or alternatively, is the court recognizing a pre-existing allocation, that the farm owner is doing something in contravention to the rights of his workers, and this idea that the court isn't making new law, but alternatively is finding law or announcing law that was already there. Or maybe we should understand this instead as a regulation imposed by the court of the property owner's exercise of his property rights. And so in comparison to Jacques versus Steenberg Holmes, State versus Schack presents some really interesting questions about legal reasoning and how the court goes about establishing its rule, and if there really is any kind of rule here. What's fascinating is the court says, well, not so much. This is kind of a particular set of circumstances that is compelling us to act in a particular way. We see no profit in trying to decide upon a conventional category and then forcing the present subject into it. So there's not some pre-existing case that has some clear legal rule that the court is enforcing here. To try to announce such a principle, the court says would be, quote, artificial and distorting. The quest is for a fair adjustment of the competing needs of the parties in light of the realities of the relationship between the migrant worker and the operator of the housing facility. So what exactly does this passage mean? It touches on a lot of really interesting questions about what judges do. One is the general trade-off between courts and legislatures. Should courts be creating exceptions to the right to exclude, or is that role properly limited to a legislature, which is more democratically accountable? And it's worth noting, by the way, that statutory exceptions to the right to exclude are commonplace. Another question concerns the trade-off between rules and standards, with a rule being something we can spell out specifically ahead of time. A classic example of a rule would be the speed limit is 65 miles per hour. It's a simple factual question whether a car was driving above or below the speed limit. In this case, a rule would have been something like, owners of farms must admit lawyers to see migrant worker clients on the premises, and then with some added details about time, specific locations, notice to the owner, what workers are eligible, and so forth. But the court doesn't give us anything like that. The alternative would be something more like a standard, which is more open and principle-based. The highway example would be something like, don't drive recklessly. It sets out a principle that is supposed to be followed, but doesn't provide a lot of factual detail on how the command is to be obeyed. And now the court hints that it's doing something standard-like in Schack, in its language about ensuring that workers have the opportunity to enjoy associations customary among our citizens. But, that's at such a high level of generality that perhaps it's even too broad to function as a standard for the future. And here, it's worth noting that the court simply says that it sees no point in trying to identify a conventional category and then forcing the facts of this case into it. And so maybe the court is functioning less like either a rule maker or a rule applier and more like a safety valve. The idea being that in general, we let property owners exercise the right to exclude in a semi-absolute kind of way. But every now and then you get a case in which the court decides it's just not working here. In case of emergency, break glass. And the court will come up with a resolution to the case that doesn't necessarily provide a prospective rule or standard that we lawyers can use to advise our clients about, but is necessary for the system to function. Like a pressure valve, it simply prevents an unacceptable result in a particular situation and then leaves the system largely intact. Of course, this view can invite the objection from some that it's not the role of courts to do this, but rather the role of the legislatures to pass laws if they think the current ones lead to problems, and this invites the rejoinder that neither courts nor legislatures can anticipate everything that might happen. There needs to be some play in the system to address the problem of the unforeseen circumstance. And then we can argue about what courts should do when exercising that leeway if we agree that that leeway is necessary. My point here isn't to advocate any side of these arguments as applied to Schack, nor is it to argue that Schack was rightly or wrongly decided. But the case does raise a lot of deep questions about the right to exclude in particular and law in general, particularly in juxtaposition with Jacques versus Steenberg Holmes. And so we'll leave it there.